Most people believe traffic stops are about safety. They're not. In Alabama, a traffic stop is a temporary detention, and the moment you forget that, you give police permission to expand it. Today, we're walking through what the law actually requires of you, how police legally escalate stops, and why reasonable articulable suspicion is the line they're always trying to cross. In Alabama, the law requires you to provide only 3 things during a traffic stop: your driver's license, your vehicle registration, your proof of insurance. That's it. You are not required to explain where you're going, answer investigative questions, engage in conversation. Every extra word is voluntary, and police are trained to use voluntary statements against you, not for you. Yes, in Alabama, police may order you out of the vehicle, even without suspicion of another crime. This authority comes from Pennsylvania versus Mimms. But this is critical. Getting out of the vehicle does not mean you consented to a search, you waived your rights, police now have suspicion. It only changes where you are standing, not what they're allowed to do. Before stepping out, if it's safe, roll up your windows and lock the car. This is legal. It prevents plain smell claims, plain view justifications, officers reaching inside. In Alabama courts, an officer saying, "I smelled something," is often enough to justify a search. Don't give them that opening. Reasonable Articulable Suspicion, RS, means specific facts that can be clearly explained, indicating a crime beyond the traffic violation. RS is not nervousness, silence, refusing consent, just a feeling. This standard comes from Terry versus Ohio. During the stop, police are limited to the mission of the stop itself. They cannot extend it to investigate other crimes without RS, affirmed by Rodriguez versus United States. Once you are out of the vehicle, something important happens. The original traffic violation no longer justifies continued detention. At this stage, police must establish new, independent RS. The stop cannot continue just because they want it to. Officers often attempt to manufacture RS by claiming, "You seem nervous, you're avoiding questions, I smell something." None of these alone meet the legal standard. If police claim you are armed and dangerous, they may perform a limited pat-down only, strictly for weapons, not evidence, under Terry versus Ohio. Yes, during a lawful detention, police may control your location for scene safety. But that control does not create suspicion, does not allow searches, does not extend the stop. Authority over your movement is not authority over your rights. There is one question that forces police to choose. Am I being detained, or am I free to leave? If the answer is no, leave. If the answer is yes, they must have RS. And you are allowed to calmly ask, what is the reasonable articulable suspicion? Not to argue, but to put the justification on the record. Police are not there to protect your rights. They are there to enforce compliance and issue penalties. Your rights only work if you assert them. Say less. Consent to nothing. And remember, silence is not guilt.